Good morning. My name is Matt Welnicki,
And I'm Alexander Zwillinger.
and we welcome you to the Kenney Sams second webinar in the Business Litigation Practice Series. In our last webinar, we talked about the differences between a claim and a lawsuit, and above all, we talked about why it was important to stay vigilant, whether it's a claim or a lawsuit. And today, we're going to talk a little bit more about how businesses can protect themselves in advance of being sued or in advance of receiving a claim or notice of a claim.
Yeah, I watched that last webinar. I thought it was great. I thought you and Anthony did an excellent job explaining the difference between claims and lawsuits, the sort of things that you have to do once you find yourself in that position. And to me, just as a takeaway from having watched it fairly recently, is like you say, to be vigilant, but also to make sure that you take these things seriously, because not taking them seriously leads potentially to bigger problems. If you're involved in a claim or a lawsuit, there's already something gone wrong. By taking it seriously, by acting fast, by getting a lawyer involved, you can prevent those problems from growing and control them. Today's webinar is different because it's what can you do now? What can you do looking forward to protect yourself from that circumstance? How do you prevent the claim from arising in the first place? And how do you protect yourself by putting in place other sorts of supports so that if you find yourself in that position where you're involved in a claim, you're involved in a lawsuit, it's not just you standing there trying to make up a solution on the spot. You've already thought these things through. You've already put in place the structure to make sure that you're protected and that your business is protected. Because in the end, that's really what we're here for, is protecting businesses like our clients and hopeful clients from problems like that. So I thought it was a great webinar. I encourage everyone to go out and watch it if you haven't seen it yet. But again, now we're talking about pre-suit, pre-claim protection. What can you do now? And really the important part of this is that you need to do these things now because for most of the kinds of things we're going to discuss, insurance, preparation and contracts, having good policies in place for your business, need to be in place now, because if they're not, it's going to be too late. These are not things that you can go back and buy, for the most part, insurance after the claim has arisen. You're not going to be able to put in place better policies after the policies have failed you. So you need to act now. So part of the purpose of the webinar today is how can you do that thoughtfully and carefully and methodically in a way that makes sure that you're thinking things through, getting yourself ready. And part of it is sort of the why. Why would you even do these things, right? I hear clients say all the time, I'm not going to breach a contract. I'm going to live up to this, and I trust the person on the other side that they're going to live up to their end of the bargain. You're risk averse. You're careful. You're not going to put yourself in a position to let something happen. But really, what you need to remember is that the claims, the lawsuits, those things come up when something unexpected happens. And the idea now is that through planning, you can expect how you're going to deal with it. You're investing in these protections now so that you have them at your disposal later. And really, it's because claims and lawsuits are bad for business. It's bad for your business to be dealing with a claim or a lawsuit that distracts you from what you were set up to do. If you are a services business, if you're a contractor, if you're a software developer, if you're anything that is going to be delivering goods and services and providing value to your customers and clients, a claim or a lawsuit is going to distract you. It's going to distract your people. It's going to distract your entire business from the thing that it's set out to do, which is going to be so much more expensive in the long run than the sort of investments and the protection that you can make now. So really, that's the purpose, is to avoid being in that stressful, expensive claims process by putting the protections in place now. So we're going to be talking about a few of the sort of pre-suit, pre-claim protections you can put in place now. Insurance is the first one. I'd say good contracts and good contract provisions, and then good corporate policies, things that you can put in place in sort of how you're running the business so that you're protected in the instance that something comes up down the road. So the first one is insurance. It's really one of the best forms of protections you can have. I think most businesses probably already have some form of insurance, but it's important to talk about because it's not protection from preventing the problems from arising. It's protection from spending more on those problems than you could if you pay the premiums up front. It's an investment in minimizing the costs and the distraction and the resources that come up down the road. And importantly, this is not going to be a comprehensive lecture on all the different types of insurance products that are out there. There's tremendous variety in what you do in your business that may require different kinds of policies, different kinds of coverage. The idea here is just to start getting you thinking about what you could be doing, what kind of products might be out there that could provide you with these sorts of protections, because there's a tremendous variety of what you do and a tremendous variety of what's available. And there are lots of people out there that make their profession helping you find the right product at the right cost with the right kind of coverage. But generally, just briefly touching on some of the ones that you should be thinking of. Well, first you should be doing sort of an analysis of what your business does. What sort of business are you in? What sort of risks do you confront on a daily basis as you're operating your business? What insurance might be available to help you protect against those particular risks that are unique to what you do? It's the kind of thing that you can be doing on your own, but it's also the kind of thing that you can do with an insurance agent or an insurance broker, many of which we work with all the time, to find the products that are right for you. Most businesses probably already have in place something like a CGL, a commercial general liability policy, which is in place to protect you from losses or occurrences with property damage or personal injury that come up during the operation of your business or through your employees' actions. Really important to have, because you never know when one of your employees is going to knock something over that's going to break an important piece of equipment at another person's factory, or do something that is going to cause personal injury to another person. You want to make sure that you have those policies in place in advance. What if your employee gets hurt themselves and they can't work? You need to have workers' compensation insurance. As you scale and you grow and you find yourself as the business owner in a position of the business's leadership, you might want to get for yourself or for the other people that are directors and officers. D&O coverage, that's going to protect the directors and officers from claims or losses or lawsuits against them individually for things that they're doing on behalf of the company. Another important one that's becoming more and more timely as technology becomes a more integrated part of every business's day-to-day operations is cyber policies, right? You can buy insurance for data breaches. If a bad actor goes out there and targets you and holds your data hostage, what are you going to do? And how are you going to address those risks? And the important thing is, when those problems come up, they're do or die, right? They're often bet the company, the whole operation is at stake. But by paying into the premium in advance, you can help avoid that sort of big risk and lower the stakes, lower the temperature when that issue comes up. There are others: auto policies, employment insurance policies, environmental. You may want to get excess or umbrella coverage that's going to cover your entire operation above policy limits. The idea here is you probably already are thinking about how you are insured now, but as you grow, as you become more complex, and as your needs change, or as you shrink and your needs change, you should be thinking about what you could be doing to protect yourself through something like insurance into the future.
Yeah. Exactly, and great points, Alex. There are many different types of insurance policies out there, and as you grow, as you contract, as your business lines change, you want to use those opportunities to review what insurance you have. And again, this is not intended to be an entire webinar just on insurance, but it is such an important piece of the protection equation that we thought we'd go into it a little bit. And I'm just going to discuss briefly about what your insurance policy or policies will look like. Generally, every insurance policy lists the coverages. It'll list the dates of coverage, the amounts of coverage right there on the deck page. That part is easy. You can take a look to see what amounts you're covered for, especially if you're in a practice where you're working with other people. If you're a manufacturer that sells something to a store, they may require you to have certain insurance coverage. If you're a contractor in the construction realm, your general contractors or owners might require you to show proof of insurance. Those are all opportunities for you to review what insurance you have and what insurance you might need. Now, again, generally, an insurance policy will list what you're covered for, Then it will list also what the exclusions are. This is also important to take a look when you get your policy or sit down with an insurance professional to make sure you haven't purchased something you thought you were going to buy that turns out it's not covered at the end of the day. And then for every exclusion, there's also exceptions. You're getting to the nitty-gritty there, but again, the point is make sure you're constantly looking at your insurance policy in the context of what you're doing. Notice if it's a claims or an occurrence-based policy, which is a whole nother lecture we could do on when each one of those applies. But again, stay on top of your insurance, work with professionals. Now, when you receive notice of a lawsuit or notice of a claim, it's important to put your insurers on notice. A lot of times insurers will try to argue that there's no coverage because you didn't give them timely notice. Again, we could go into a whole seminar on that alone. But the key point here is timely notify your insurance company. Now, we often hear that some businesses don't want to notify their insurance companies. They want to take care of the issues themselves because they're afraid their premiums may go up. That may be the case, but before you make that decision, try to consult with a professional, either an attorney or an insurance professional, to find out if that really is the case and long-term whether that's the best result. Because sometimes up front, what may appear to be a very small notice of claim can turn out to be a big lawsuit.
You know who I found to be helpful for something like that is talking to your broker, right? Because before you make a claim to the insurer, you can talk to your agent who helped you buy that policy, who knows what you're going to look like as a potential insured when you go to market next time, and they can help you sort of navigate that decision-making process. In addition to talking to your attorney about sort of, is this a claim that's worthy of going to your insurer and filing a claim, your broker is going to know exactly what that insurer, how that insurer is going to react.
Exactly. And another reason why you want to look at your insurance policy fairly closely and all the documents the insurance company provides is because there are some instances where insurance companies offer free services or discounted services for risk management, something we're going to get into in a little bit today. But if they have that option, definitely take the insurance company up on it. Again, the insurance companies have a vested interest in your company being protected from future claims and lawsuits because they're the ones at the end of the day that generally are going to be paying the defense costs. And as Alex alluded to in the beginning, oftentimes it's not the end result of the litigation that's hurtful to a company. In other words, the judgment or any amount you have to pay at the end of the day. A lot of times it's the defense costs, it's the burden, it's the taxation of resources on your company. If you're manufacturing widgets, you'd be better off manufacturing widgets and using your time on that than being sued and defending in a lawsuit.
Yeah, so insurance is an important product that you could buy from a third party that's going to provide this protection. But even before that, there's an opportunity to negotiate an indemnification provision in your contracts between you and your counterparties, right? So you don't need necessarily a third party insurer who's in the business of providing that protection. You can make that part of your contracts right up front. So indemnification is an important thing to consider. Indemnification is essentially where one party looks to the other to help pay for the losses that the other side has caused or that they've encountered for another reason, as long as it's part of the negotiated terms of the indemnity provision. An important thing with an indemnity provision, unlike perhaps an insurance company where the big insurers are probably going to be there, they have reserves, they're set up to deal with these kinds of claims. An indemnity provision really is only as strong as the party that's indemnifying, right? So you need to be thinking about, is this person that's providing indemnification here solvent? Are they creditworthy? Are they going to be there when I need them? Are they going to respond the way they should? An insurance company is regulated, right? There's regulations for how the insurance company needs to deal with your claims. An indemnitor in an indemnification provision amongst the parties may not be so careful and may not be as accommodating. So be really careful with how you're valuing that kind of provision, but it can be an extremely valuable one. Think about ways that you can get something more from it than just an indemnification provision. Can you get a personal guarantee from the business owner, right? If you're a small business and you're dealing with another small business, the business may be incorporated to help try to judgment-proof its owners, but you can demand that the owner of the party that you're dealing with, the business you're dealing with, puts in a guarantee to ensure that you're not dealing just with this small shell, a holding company, but you're dealing with the person that you're sitting across the table from. That's something that you can negotiate and can provide tremendous protection and also tremendous incentive for the other side to do the right thing, because they have skin in the game just like you do. It's a great way to sort of allocate the risk and plan in advance for things that you hope don't come up, problems that you hope you never see, but that you have in place already. The other thing is, does the party that you're dealing with have insurance themselves, and can you get an additional insured coverage, right? We see it all the time with owners and general contractors and subs and vendors all the way down the line, where everybody is asking for the next person in line to provide additional insured coverage and proof of insurance up the line to make sure that if there's something that goes wrong on a construction project, we do a lot of construction litigation here, you want to make sure that every link in the chain has insurance, and that it's naming you if you're the one that can take advantage of it, and you want to make sure that you get proof that they have that insurance. That additional insured coverage is really important. We see it in construction, but it comes up other places. Recruiting companies, products liability, manufacturers, anywhere that you're dealing with another party, another business, or a customer that's going to use your products to go do something else. There's an opportunity there to get additional insured for you to make sure that you're protected by their policy.
Exactly. And as we see businesses grow, a lot of our clients, we've been fortunate enough their clients tend to grow over time. And as they grow, they expand into different areas that they provide services or products for. And when that happens, they want to be especially sure that who they're dealing with and the industries that they're moving into, they're protected. Again, a chance to not only look at what insurance coverage you have, but the insurance coverage the other companies, their business partners, so to speak, have as well. And especially in a situation where a business is moving into a new area of services, you want to take a look to see if you can get that additional insured coverage through your counterpart, because it's insurance that they're probably more familiar with. Now, we've spent a lot of time already talking about insurance and contract language and ways to protect yourself really if something goes wrong. We'd like to shift the focus here because it's equally important to make sure things don't go wrong in the first place. So there are certain things businesses and companies can do at the outset of their existence, while they're in existence, as they're moving from one area of services to another. And the first one we're going to talk about right now is risk management.
Yeah, and one of the first places to start with risk management is with good contracts. Not to belabor the importance of having contracts. Indemnity provisions are an important part of that, but having good contracts generally really is the best protection from dealing with a contract claim down the road. As litigators, we see very often that parties come in with a contract that they think means one thing and is governing the parties' relationship in one way. And then when you really read it and you really think about it, sort of in the lens of an outsider, you realize it doesn't quite mean what they thought. So an important part is to make sure that your contracts are clear. They're unambiguous, that you've identified the risks and you've accounted for them, and you've allocated those risks to one of the parties. Those are all things that you could do for contracts that you're entering into now and into the future, so that you're protected from claims in the future. But you can also revisit contracts that you have right now. You have almost certainly a whole stack of contracts, whether on four corners of a piece of paper or in a series of emails or a handshake, that are governing the key relationships of your business, each of which can be improved or at least understood better. We're happy to help with that sort of thing. I know lots of lawyers would be happy to do that. It's frankly a good inexpensive way to ensure that you avoid problems down the road, that you avoid claims and lawsuits down the road, because you need to understand what you're responsible for. You need to understand what your employees are supposed to be doing. Again, thinking like a construction litigator, does your billing coordinator who's sending out the pay recs know precisely what needs to be included in every one of those pay apps? Contracts are different from project to project. Every single one of them has different terms that the better you understand, the better you can comply, and the better that you can ensure and cut off problems down the future. So really, one of the first risk management things you should be doing is looking at the contracts you have already, thinking about your contracting policies and procedures into the future to make sure that you're coming up with good contracts that protect you and that you can live with going into the future. And one of the things that, again, each one of these topics could be a 30-minute seminar and years-long litigation on its own, unfortunately. But there are lots of things that you can be thinking about now in your contracts that can help you. So if you're thinking about pre-suit, pre-claim protections, things like limitations of liability provisions, super important way to ensure that the scope of the potential damages are limited to something, limited to the amount that you paid into the contract, to a particular amount, key to something else. There's so many ways that you can protect yourself. How long do the protections in your contracts last? Is there an attorney's fees provision that's going to shift who pays for the legal costs if something goes wrong with the contract and one party is forced to bring an action or a claim to enforce it? Liquidated damages provisions that are enforceable if you want them enforced. Waiver of consequential damages. So many individual terms that you can make part of your repertoire now as you're negotiating new contracts or renewals of contracts or modifying and amending them to make sure that you're protected. Additionally, there's types of contracts, right? You can get NDAs, non-competes, all kinds of things that you can be doing now in your contracting so that you are protecting your business for the risks that it is confronting every single day, so that if you find yourself facing a claim or bringing a claim, you're in a position of strength rather than a position of weakness.
Exactly. And one of the things I'd like to just touch on briefly here is when we speak with a lot of general counsels for large and small businesses, and we often hear that there's a dynamic in the company where you may not have everyone on the same page with respect to what a contract says or what it should say. You could have the sales department wanting to get the deal done and willing to agree on a handshake on certain terms and not include things in contracts just to get that deal done. And then you have the legal department insisting on very rigid, formulaic, often archaic language in that contract, which sometimes the sales force doesn't understand why it needs to be there. And sometimes the general counsel's office doesn't understand why the sales force really needs something in a provision to get that deal done. So making sure everyone within the company is on the same page with respect to contracts, especially the bigger contracts, making sure that there's some feedback and input by all stakeholders involved early on really goes a long way to preventing problems down the road. Now, aside from contracts, there are other things companies can do to make sure they're protected later on. And it all starts with corporate formation. There are different types of businesses you can form. You can have limited liability companies. You can have corporations, S Corp, C Corp. There's different tax advantages to them. The main thing is that you're incorporated and protecting the principles of the company from personal liability. And this is something that shouldn't be considered after a lawsuit or possible lawsuit happens. This is something that should be considered right at the outset. Getting advice early on can not only help with tax issues, but can help if there's mergers later on, acquisitions, any type of corporate transactions later on down the road. So again, it all starts with formation. And then it proceeds on through having a good handbook in place. We will be doing a webinar on some employment-related business litigation matters, but having a good handbook early on and then checking that handbook, making sure it's updated. The handbook is really a place where you can have different policies and procedures in place and have everything all in one area. Now, obviously, you have to balance between having some rigidity and consistency with some flexibility. But the one thing that you have to be sure is as your business evolves, and just as the world evolves, you're able to update your policies and procedures. A great example is 20 years ago, most businesses probably, maybe they did, and I'm dating myself, but a long time ago, many businesses did not have personal computers at each of the desks of their employees. Now that we have computers everywhere and everyone's on the internet, there needs to be more dynamic policies and procedures in place with employee internet use. And when we get into litigation and we go into document production and all those issues in later webinars, we're going to see how those corporate internal policies and procedures regarding email use and web internet use becomes very important. Now, there are also situations where your business may be in a regulated industry, an FDA industry, selling insurance, The laundry list is long as to what types of industries are currently regulated. In those instances, you may want to consider hiring an outside professional to do an audit of your practices to make sure that if the government comes in or the regulators come in, you don't have problems at that point in time. Doing that regularly is something that you can use to your advantage. Make sure that you're using professionals to help you. Again, like insurance, like having good contracts, like having good risk management, having some of that resources spent up front may prove invaluable later on to avoid litigation or avoid claims. So you always want to keep in mind those types of issues. No two businesses are alike. No two businesses are evolving the same way. No two businesses are dealing with the same customers. That's why it's important to keep reviewing what you're doing at the start and throughout your business life. One other area we'll touch on briefly, and again, we've talked a lot about topics that are going to be also touched on in more detail in later webinars, but one of them is document retention policies. Every business has contracts. We talked about that. Every business nowadays is involved with email communications. It's important to set from the beginning how you handle those documents. So if there is later litigation, if there is a later claim, those documents are preserved, those documents are protected, and there's no accusation that you're trying to hide the ball. It's also important because as your business grows, you're going to want to be able to look back and see what went right and what went wrong, how you can improve your business, what you can do differently next time. Alex talked about contracts. You may have some bad contracts right now. You want to hold on to those bad contracts, even though you may not want to revisit them, but you may want to look back and see what worked, what didn't work, what you can improve on next time. And again, we'll talk about that more in the litigation context in a later webinar, but for now, that's one of the important policies and procedures you want to have from the start.
Yeah, and this may be getting into what I think will come up later, but as litigators, what we see often is the need to look at those documents and have those documents to provide during discovery. So you want to make sure that you're keeping them safe, that you're keeping them for long enough that you're meeting whatever reporting requirements you might have, and that they extend to all the different issues that we've been talking about today, or all the different risks that you're identifying. Right. Part of this is you're thinking now about what your business could look like in the future and how you're going to protect your business in the future. And as you're doing that sort of mental review for yourself and evaluation of the risks that you see, you give some thought to what documents you might need if a problem arises in the future. What documents do you have now that you're going to potentially have to rely on, or the other side's going to demand if a claim or a lawsuit comes up? So again, as a business litigator, I'm always interested in getting as many documents as easily as I can, but you need to, as a business owner or as a business manager, thinking about now, where am I keeping them? How am I keeping them? How am I going to access them in the future? Because if in that circumstance a claim or a lawsuit arises, you want to be able to get your hands on those things and use them quickly and easily. But that starts with good policies early on.
So again, we're going to recap just by noting that it's very important to stay vigilant. Very, very important. Another thing we touched on today is don't be afraid to ask for help. Normally when business founders and owners start up their company, they're used to doing everything themselves. They started as a small business in their garage. They started with a group of friends, and they're used to doing everything by themselves. But as your business grows, you need to reach out and use the resources that are available to you. In that way, you're able to cut off any future problems that may arise, or at least reduce the burden on you. So again, thank you for attending today's webinar. Our next webinar is going to be on the first steps in what to do after receiving a notice of claim or being sued. Today we talked about how to avoid that. If you're going to be checking in with us in our next webinar, perhaps you've been sued, received a notice of claim, or just want to prepare for it. Either way, I think it will be an important one for you to attend. Thank you.
Thanks very much.